Good afternoon, everyone. This will be my video lecture in legal aspects in the tourism and hospitality industry. So now, today is October 13, 2022. It's a Thursday afternoon, and we will continue with our discussion on obligations and contracts. No? Last time, we talked about the three essential requisites of a contract. And what are they again? So when we talk of contracts, of course, when we talk of contracts, we are talking about, when we talk of this contracts, we are talking about in the Philippines, no? More on written contracts. More on written contracts. Why? Why do we refer contracts here as more on written contracts? Because written contracts in our country are what we call enforceable. What do you understand by the word enforceable? Well, enforceable meaning it can be presented in court as evidence. No? It will be presented in court as evidence. So when we talk contracts, we are talking about here in our jurisdiction, in our country, we talk more of written contracts because written contracts are the ones that are enforceable. Now, last time, we talked about the three essential requisites of contracts. No? If you still remember the COC, of course, we talk about consent, we talk about the object, certain, and we talk about what we call the cause. No? This one we have to clarify this a little bit more. No? So of course the consent, as I've told you, consent given by whom? Well, by the parties themselves. No? Given by the parties. And who are the parties to a contract? No? Who are the parties? Well, it depends on the contract. No? It depends on the contract. But generally, when we talk of the parties, we are talking about who? Well, it depends really on the kind of contract, no, that we're talking about. Object certain would of course be what ought to deliver. Remember that contracts, in contracts, to give something, no? To give something or to deliver something, no? To deliver something or to render some service, diba? Some service. So it's either a thing or it's to give something, a thing or a service. That is the object. Now, when we talk of the cause, we are talking about the why, no? The reason behind the parties entering into a contract, no? And of course here, in the case of consent, it has to be freely given, no? Freely given. It has to be intelligent. It has to be spontaneous, no? Spontaneous. So you have to qualify. And here for the object, it has to be certain or capable of being certain, no? Clear? This is just a review because I have discussed this in our previous meeting, so I will not dwell on this matter anymore. So let us just take a contract, an example of a contract. Now, say for instance, a contract of, say for instance, lease, no? Contract of lease. You are leasing an apartment, for instance. Sometimes this is, in some jurisdiction, they call it as the contract of tenancy, no? Tenancy, no? So this is just a specific example of a contract, no? So here the parties would be, the parties here, we have to define the parties. The parties in a contract of lease will be what we call the lessor and the lessee, no? Lessee. Lessor and the lessee. Now, who is the lessor? No, and who is the lessee? This one in other jurisdiction, they call this the, when we talk of the lessor, we are talking about the, here we call this the tenant, no? And the one who leases is what we call the landlord, no? This is just an example, no? The landlord, the one who leases, and the one who leased is the tenant, no? So here, these are the parties that we have. The parties, of course, they have to give their consent before signing the contract. So they have to give, these parties will have to bilaterally give their consent. It's not only one person who will give his consent, but both of the parties. Clear? So far? So they have to extend their consent, and this consent could either be express or implied. But of course, express or implied. But of course, the consent should be communicated to the other party. It has to be communicated to the other party, so that the other party will give his what we call acceptance. Clear? By acceptance, it has to be accepted. No, because the one that offers, no, the offer has to be accepted by the other party. Okay, clear so far? Now, I'd like to say, okay, we just talked about the parties in a contract of lease. Now, of course, the object certain in a contract of lease, object certain in a contract of lease would be what? Well, the thing that is being leased, whatever is that, the thing that is being leased. Say for instance, if it is an apartment or a land, for instance, or say for instance a movable property like a vehicle, no, would also be leased. Clear? So this is the object certain. Remember that you need to be specific as to the apartment, as to the land, or to the vehicle. No? And then of course the cost. What is the cost again? It's the why. It's the reason why the parties have entered into a contract. No, the cost is the why. Why or reason. Why the contract was entered into in the first place. Well, on the part of the lessor, who is the lessor again? The lessor is actually the landlord. No? The landlord. And the lessee is the tenant. Now here, what is the cost? Why did the lessor enter into the contract? Well, of course, the compensation or compensable sum, no, over the lease, compensable sum, or the remuneration that we call remuneration. Remuneration of what? For the use of his property, no? The compensable sum, and on the part of the lessee, the use of the property. These are the reasons. So take note, no, they have different reasons, no. On the part of the lessor, perhaps the money that will be paid by the lessee, the tenants, the lessee, and of course the cost by which the lessee entered into the contract is because he wants to use the property. That's how you view it, no. So I will teach you, because when we talk of contracts, you have to be very careful. Before signing a contract, you have to read, no? Remember that once contracts have been signed, these are enforceable. What do you mean by enforceable again? Well, once the contract has been signed, it could be used as evidence in court. And once you have signed that document, the contract or any legal document for that matter, you cannot retract from the terms and conditions of that contract. The terms and conditions that are contained through clauses or stipulations. Clear so far? So you have to be very careful then that before signing any legal document, you have to read all its contents. Why is that? Because that document is enforceable later on. And once that has been presented as evidence in court, then you will be bound by all the terms and conditions, by all the clauses, by all the stipulations contained therein. Why? Because you have affixed your signature. No? Affix your signature. Diba? So you have to be very careful. Now, later on, when you put up your business as a tourism professional, of course you will be encountering a lot of legal documents. And mind you, I advise you that before signing any legal document, you have to bear in mind that there may be some what? In that document or in that contract, there may be some gray areas. No? There may be hidden problems there. No? So you have to be very, very careful, because once you neglect or ignore these gray areas or hidden problems that may be contained in that document, well, this may cause bigger problems. Yeah? Bigger problems. This might cost you a lot of money. Well, that's why Bill Gates, you still remember Bill Gates, no? Microsoft, he said that in business, what did he say? In business, it might be too late for you to realize that you're in trouble, and it might be difficult for you to save yourself because you have made already that problem big, no? So in business, according to Bill Gates, no, it might be very difficult for you to save yourself already once the problem is already very big, no? So that you could avoid any big or bigger problems, of course, you have to read the contents. Read the contents of the contract. Now, I will teach you how, no? So that you can protect yourself sooner or later, no? Before you enter into a contract, no? Before you enter into a contract, bear this in mind as guidelines, no? Remember this, no? Read and understand. The first one is read and understand, no? So this is the first guideline that you should remember before signing any contract. Read and understand the smallest details, no? Do not just concentrate your reading on the bigger detail, on the bigger aspects, no? So in short, even the smallest details you should also read, because here you might have a problem on legal language is very different from what we call business language, no? Business language. Well, it would be better for you to understand also legal terms or nomenclatures, because that will save you from a bigger problem. So in short, before you affix your signature to a certain contract later on, when you are already in business or you are already being employed by a certain company, you have to read and understand even the smallest details. That is the first thing that you should do. No, these are just reminders, no? Because later on you will be engaging in business, or you will be engaged, your services will be engaged by somebody else. So you have to be very careful in signing a contract, no? Now, of course, you have to study, no? all the clauses and stipulations in the contract. So it might be also advisable for you to delay your signature. No? Delay your signature. No? You have to delay your signature because this might be, you may be a little bit apprehensive about certain terms, so you need to clarify. No? Clarify all the hidden problems. No? Clarify all the hidden problems or gray areas. No? Very, very important. You have to clarify all hidden problems or gray areas so that you will be able to satisfy yourself that what you are signing is actually valid for all intents and purposes. No? You will not be caught flat-footed later on once the document will be presented. Okay? The third is, of course, well, this is not promoting ourselves. No? Seek professional advice. No? You have to seek professional advice. What I mean by professional advice is somebody who is knowledgeable about laws and lawyers or any law graduate, perhaps who already understand. No? Seek professional advice. Do not concern yourself with the fees that you have to pay. Anyway, this will just be paid at a one-time basis. No? So you seek professional advice from lawyers. Of course, the fourth one is, of course, before signing a contract, no, you have to uncover law violations. Uncover law violations. No? Meaning, when we talk of uncovering law violations, what we're talking about is that all the terms and conditions should be consistent with local laws. No? Should be consistent with local laws. No? When we talk of being consistent and valid for all intents and purposes with local laws, it should not be against. No? It should be consistent with local laws, should not be against, should not be against public policy, morals, no? Public order, etc. No? Should not run counter against public policy, morals, public order, and all other considerations. Okay? That is the fourth. The fifth reminder before you sign a contract, the fifth reminder for you people is, of course, know your rights. You have to know your rights and duties. Know your rights. Know your rights and duties. No? When you sign that contract, it has to be a balanced document. No? It has to be a balanced document wherein your rights and duties have been carefully specified therein, and that it should not be tilted in favor of one party or the other. No? It should be a balanced document. No? Balanced document. When I talk of balanced document, of course, no one is agraviado. No one is aggrieved by the other party. No? It has to be a balanced document, specifying your rights and specifying also your duties to that contract. Okay? 6. One, of course, that you should remember, get everything in writing. No? Get everything in writing. No? Get everything in writing. rely on oral promises. No? No matter how trusted that person you are relying on, do not rely on oral. No? Oral promises. It has to be, everything has to be in writing. Every promise has to be in writing. No? Otherwise, you might be affected by all these verbal promises, and then voila, there is nothing at all in the document. And then finally, remember, as I told you time and again, that a contract is legally enforceable. It's legally enforceable, so you have to be very careful in signing this document, because once it is presented as evidence, then you cannot escape yourself and say that you do not know the contents, because you have already signed the document. It will just be presented, and that is already considered as acceptable evidence. Okay? I think I have given you enough reminders that before signing a contract, you have to study carefully. No? You have to study all its provisions, all the stipulations, all the clauses, because once you have affixed your signature therein, every clause, every stipulation, or every term, you will be bound. Okay, I think that is all for today. Good afternoon, everyone.